Hi, so today we'll be discussing obligations according to plurality of objects. So we have simple, multiple, and conjunctive. For conjunctive obligations, it is where the debtor must perform more than one prestation. So question, A promised to deliver to B his carabao, dog, and goat. Again, the question is, A promised to deliver to B his carabao, dog, and goat. What kind of obligation is this? The answer is conjunctive. Sabi nga natin kanina, in conjunctive obligations, it is where the debtor must perform more than one prestation. In the question given, sabi, A promised to deliver to B his carabao, dog, and goat. So there are three prestations in the question. So the correct answer as to what kind of obligation is this, the right answer is conjunctive. Not simple, not multiple, but conjunctive. So for alternative obligations, it is where the debtor must perform any of several prestations. Again, the keywords are any of the several prestations. The debtor must perform any of several prestations. Okay? When several objects are due, the fulfillment of one is sufficient. Generally, the debtor chooses which one. So, si debtor, nasa sa kanya ang choice or option kung ano doon sa several objects na kailangan ang kailangan niyang i-fulfill. Sa facultative naman, facultative obligation is one where only one thing is due. Only one thing is due, but the debtor has reserved the right to substitute it with another. Kindly refer to Article 1206. So, election here is never granted to creditor, na kay debtor, ha? So, question, in conjunctive obligation, the right to choose is always with the debtor. Is that correct? The answer is no, because no right to choose dahil lahat kailangang i-perform. Diba sabi natin kanina, sa conjunctive, the debtor must perform more than one prestation. Another question. In alternative obligations, the right to choose can be given to third person. Is that correct? The answer is yes. Kindly refer to Article 1000. As long as it is not contrary to law, morals, public order, public policy, and etc. So in an agreement where there is no stipulation as to who has the right to choose, paano ito? In an agreement where there is no stipulation as to who has the right to choose, the answer is it depends, okay? If alternative ang obligation, generally the debtor chooses. If facultative, only the debtor. Again, pag walang stipulation as to who has the right to choose, you have to determine first if the obligation is alternative or facultative. Hindi na kasama yung conjunctive because all of the prestations should be performed in conjunctive obligations. However, if it is alternative, then generally, the debtor chooses. Again, generally, the debtor chooses. If facultative naman ang obligation, it is only, the right to choose is only with the debtor. So what if the debtor has the right to choose and he delays? The correct answer is the right is not lost by mere delay because the creditor may file his action. Okay, let's discuss alternative obligations. Kindly read Article 1199. It states that a person alternatively bound by different prestations shall completely perform one of them. The creditor cannot be compelled to receive part one and part of the other undertaking. So according to Professor Tolentino, the characteristic of alternative obligations is that several objects being due, the fulfillment of one, only one, is sufficient. So please also read Article 1200. It states that the right of choice belongs to the debtor unless it has been expressly granted to the creditor. The debtor shall have no right to choose those prestations which are impossible, unlawful, or which could not have been the object of the obligation. Another question. To whom does the right of choice belong here in alternative obligations? Again, as a general rule, to the debtor. Your reference would be Article 1200. The only exception is that when it has been expressly granted to the creditor. Here, you cannot simply imply that the right of choice belongs to the creditor. It must be expressly granted, okay? There is a third possibility where the choice may be made by a third person upon agreement of the parties. And this too shall be expressed and cannot merely be implied. So what is the technical term of the act of making a choice in alternative obligation? The correct answer is concentration. Again, concentration is the technical term for the act of making a choice in an alternative obligation. So the right to choose is indivisible. The debtor can choose part of one prestation and part of another. Here, the plaintiff's action must be in alternative form. Article 1201. The choice shall produce no effect except from the time it has been communicated. So, as a requirement of communication of choice, if the choice belongs to the creditor, of course, he has to communicate his choice to the debtor, okay? Again, if the choice belongs to the creditor, of course, he has to communicate his choice to the debtor. The debtor is not a prophet. Hindi siya manghuhula kung ano ang choice ni creditor. So, kailangan ipaalam sa kanya ni creditor kung ano ang napili niya. So, wala naman ditong required form. It may be oral, in writing, tacitly, or other and unequivocal means. So, if the choice belongs to the debtor, why require communication before performance if the choice belongs to him anyway? Sabi dito, if the choice belongs to the debtor, kung yung choice daw na kay debtor, bakit kailangan pang i-communicate before ng performance kung nasa kanya naman yung choice? Okay, bakit daw kailangan? The answer is to give the creditor an opportunity to consent to the choice or impugn it. This is based from the case of Ong versus Sempudi. So, you have to also read 46P 592. Ito yung case ni Ong versus Sempudi. To give the creditor an opportunity to consent to the choice or kumontra. Kung papayagan niya or kukontrahin niya yung choice ni debtor. But how can the creditor impugn if the choice belongs to the debtor? So the better reason would be to give the creditor a chance to prepare for the performance. Again, the better reason would be to give the creditor a chance to prepare for the performance. Okay? So it is not consent. Only the declaration of choice made communicated to the other party unilateral act or unilateral will. So Articles 1202 to 1205 talk of the loss of some of the prestations before performance. Okay. So ito, i-discuss naman natin if the choice is na kay debtor. Okay? When only one prestation is left, iisa na lang ang natitira. Whether or not the rest of the prestations have been lost through fortuitous event or through the fault of the debtor may perform the one that is left. Article 1202. Article 1202 states that the debtor shall lose the right of choice when among the prestations whereby he is alternatively bound, only one is practicable, okay, or practicable. If the choice is limited through the creditor's own acts, the debtor can ask for resolution plus damages. Article 1203, if through the creditor's acts, the debtor cannot make a choice according to the terms of the obligation, the latter may rescind the contract with damages. And if everything is lost through the debtor's fault, the latter is liable to indemnify the creditor for damages. Let's go now to Article 1204. The creditor shall have a right to indemnity for damages when, through the fault of the debtor, all the things which are alternatively the object of the obligation have been lost, or the compliance of the obligation has become impossible. So, the indemnity shall be fixed, taking as a basis the value of the last thing which disappeared or that of the service which last became impossible. Damages other than the value of the last thing or service may also be awarded. If some things are lost through the debtor's fault, the debtor can still choose from those remaining. Again, if some things are lost through the debtor's fault, the debtor can still choose from those remaining. If all are lost through fortuitous event, then the obligation is extinguished. If all the prestations but one are lost through fortuitous event, and the remaining prestation was lost through the debtor's fault. Ito if all prestations but one are lost. So, lahat ng prestations ay nawala maliban sa iisa, at yung iisang naiwan na yon na nakaligtas from fortuitous event, nawala dahil sa kapabayaan or kasalanan ng debtor, then si debtor is liable to indemnify the creditor for damages. On the other hand, if all but one are lost through the fault of the debtor, ito naman lahat nawala, lahat ng prestations nawala through the fault of the debtor. Pero may nag-iisang naiwan, at itong naiwan na to nawala ulit dahil sa fortuitous event, the obligation is extinguished. Okay, ulitin natin yung last two Dun sa una, lahat ng prestations nawala through fortuitous event, may iisang natira. At itong iisang natirang to nawala pa dahil sa debtor's fault, si debtor magiging liable kay creditor for damages. Doon naman sa last, lahat ng prestations nawala through the fault of the debtor, dahil sa kapabayaan ni debtor, at may nag-iisang naiwan, at itong naiwan na to ay nawala dahil sa fortuitous event, the obligation is extinguished. Okay. Tapos na tayo doon sa pagnakay debtor ang choice, right of choice. Dito naman tayo sa ang right of choice na kay creditor. You have to read Article 1205. 1205 states that when the choice has been expressly given to the creditor, okay, the choice has been expressly given to the creditor. Sabi natin kanina, it cannot be implied na ang may right of choice ay si creditor because it's a general rule in an alternative obligation. Ang choice, right of choice is with the debtor. General rule lang yun, may exception. Pag the right of choice has been expressly given to the creditor. Here, in 1205, sabi dito, when the choice has been expressly given to the creditor, so binigay kay creditor ang right of choice, the obligation shall cease to be alternative from the obligation shall cease to be alternative from the day when the selection has been communicated to the debtor. Until then, the responsibility of the debtor shall be governed by the following rules. Ano tong rules na to? If one of the thing is lost through a fortuitous event, he shall perform the obligation by delivering that which the creditor would choose from among the remainder, or that which remains if only one subsists. Again, if one of the things is lost, okay, supposing merong 4 na prestations, okay, nawala yung isa through a fortuitous event, he shall perform the obligation, si debtor, he shall perform the obligation by delivering that which the creditor should choose. So, meron pa siyang 3 options si creditor. Okay? Ipaperform ni debtor kung ano yung pipiliin dito sa 3 ni creditor. Okay? Or that which remains if only one subsists. Okay? Kung isa na lang yun natira, iperform to ni debtor. Number 2, if the loss of the thing occurs through the fault of the debtor. Okay? 4 to. Nawala yung isa dahil sa kasalanan ni debtor. The creditor may claim any of those subsisting. Pwedeng mamili dito sa 3 si creditor, or doon sa price nitong nawala dahil sa fault ni debtor. Okay? Plus, right for damages. Sabi kasi dito, if the loss of one of the things occurs through the fault of the debtor, si creditor may claim any of those subsisting or the price of that which through the fault of the former, through the fault of the debtor, has disappeared with the right to damages. Okay, number 3 naman, if all the things are lost through the fault of the debtor, lahat to nawala dahil sa kasalanan ni debtor, the choice by the creditor shall fall upon the price of any of them, also with indemnity for damages. Okay. The same rules shall be applied to obligations to do or not to do in case one, some, or all of the prestations should become impossible. So, if one or some are lost through the fortuitous event, the creditor may choose from those remaining. That's Article 1205, Paragraph 1. If one or some are lost through the debtor's fault, the creditor has a choice or has to choose from the remaining or the value of the things lost plus damages. Article 1205, Paragraph 2. And if all are lost through the debtor's fault, the choice of the creditor shall fall upon the price of any of them with indemnity for damages, and that's Article 1205, Paragraph 3. If some are lost through the creditor's fault, the creditor may choose from the remainder. Okay? If all are lost through fortuitous event, the obligation is extinguished. And if all are lost through the creditor's fault, the obligation is extinguished. So, distinguished, itong alternative obligation, distinguished from facultative obligation, you have to read Article 1206. So, when only one prestation has been agreed upon, but the obligor may render another in substitution, the obligation is called facultative. Okay? Dito sa facultative obligation, nagre-reserve ng right si debtor na magkaroon ng substitute doon sa prestation, doon sa principal prestation na kailangan niyang i-perform. So, the loss or deterioration of the thing intended as a substitute through the negligence of the obligor does not render him liable. But once the substitution has been made, the obligor is liable for the loss of the substitute on account of his delay, negligence, or fraud. Okay? Again, yung loss or deterioration ng thing intended as a substitute. Okay, so dito merong principal prestation, merong substitute. Okay? Kung itong substitute na to nawala dahil sa negligence ni obligor, okay, walang kasalanan si obligor kasi nandito pa yung principal prestation. However, once na nagkaroon ng substitution, so, may substitute, may principal prestation. Gustong palitan ni debtor yung prestation niya. So, tatanggalin niya tong principal prestation, papalitan niya ng substitute. Okay? Pag na-communicate niya na yung substitution kay creditor at nawala itong substitute na to, na ngayon ay siya na yung principal prestation, the obligor is liable for the loss of the substitute on account of his delay, negligence, or fraud. So, what are the differences between alternative obligations and facultative obligations? So, as to the contents of the obligation, there are various prestations, and all of which constitute part of the obligation in an alternative obligation. On the other hand, in facultative obligation, only one principal prestation constitutes the obligation, the accessory being only a means to facilitate payment. As to nullity naman, in alternative obligation, the nullity of one prestation does not invalidate the obligation, which is still in force, with respect to those which have no vice. As to the facultative obligation, the nullity of the principal prestation invalidates the obligation, and the creditor cannot demand the substitute even when this is valid. As to choice naman, in an alternative obligation, the right to choose may be given to the creditor. In a facultative obligation, only the debtor can choose the substitute prestation. As to the effect of loss, in an alternative obligation, only the impossibility of all the prestations due without fault of the debtor extinguishes the obligation. In a facultative obligation, however, the impossibility of the principal prestation is sufficient to extinguish the obligation even if the substitute is possible. So, facultative obligations always involve choice by the debtor. In theory, it is easy to distinguish a facultative obligation from an alternative obligation. But in practice, it is difficult to distinguish the two. You just have to find out what the parties really intended. So only one prestation is due and enforceable by the creditor at the time of choice sa facultative obligation. If the substitute becomes impossible through the fault of the debtor, the obligation is not affected, thus no damages. If after choosing the substitute and the choice is communicated to the creditor, the principal prestation now becomes impossible. The obligation is not extinguished but has become a simple obligation that must be performed, and he will be liable for damages in delay, neglect, or bad faith. If principal obligation becomes impossible by fault or negligence of the creditor, the debtor cannot be compelled to perform the substitute. Dahil there is no more substitute, it becomes a simple obligation, and now the obligation is extinguished. In an alternative obligation, sabi natin kanina, andyan si obligee or the creditor and si obligor or the debtor. In an alternative obligation, as a general rule, na kay debtor ang right of choice. Right of choice. Ito ang general rule. Okay? This is only the general rule. As an exception, okay, if the right of choice has been expressly given to the creditor, kailangan expressly given kay creditor. Hindi pwedeng by implication lang. Or hindi pwedeng implied lang. Okay? So, sa alternative, may several prestations. Ano yung several prestations? For example, si debtor oblige kay creditor na magbigay ng either dito sa mga prestations. Ano yung mga prestations? One, pwedeng dog. Isang pwedeng dog ang ibigay niya. Pwedeng cow. Pwedeng goat. Pwedeng carabao. Okay? Sa alternative obligations, there are several prestations. May 4 prestations given. Okay? Kahit ano sa apat na yan ang iper-perform niya. So, kung ang choice ni debtor ay ang pagbibigay ng cow, that is valid. And that is the essence of alternative obligation. Any one of several prestations ang kailangang i-perform ni obligor or ni debtor. Okay? Comparing it to facultative obligations. Sa facultative obligation, meron syempre ulit obligee, merong obligor. Okay? Si obligee ay si creditor. Si obligor ay si debtor. Dito sa facultative, may principal prestation and may substitute. Okay? So, ang right of choice dito sa facultative is always with the debtor. Now, si debtor, si A, meron siyang obligation kay B na magbigay ng isang Mazda 3. Okay, na car. 2016 model. Okay, yan ang kanyang principal prestation. Okay, meron siyang substitute na inilaan. Ang substitute niya ay isang Mazda 2. Pero 2015 model. Okay? What happens now kung nawala si principal. Ngayon, nawala itong principal prestation which is the Mazda 3 2016 model. Anong mangyayari? Now, the obligation is extinguished. Bakit? Kahit may substitute pa, pag nawala yung principal, may extinguish yung obligation. How about if kung ang mawala naman is si Mazda 2, which is the substitute. Tapos nandyan pa rin si principal prestation. Here, the obligation is not affected because nandyan pa si principal prestation. How about if si substitute, okay, kinommunicate ni debtor ngayon kay creditor na isa-substitute ni debtor itong Mazda 3 kay substitute na Mazda 2. Now, si substitute na ang magiging principal prestation. Ito wala na siya. At nawala si substitute. Anong mangyayari? Okay, magiging liable ngayon si debtor kay creditor for damages. Bakit? Syempre, hindi na siya facultative obligation. It is now a simple obligation. Wala nang substitute Ngayon, itong substitute natin na Mazda 2, 2015, ang magiging principal prestation at nawala pa through the fault of the debtor. Now, itong original na facultative obligation, dahil wala na to, magiging simple obligation na lang siya, and the loss of the prestation will result to the liability of the debtor to the creditor for damages. Okay, yan ang difference ng alternative and facultative obligation. As to the rights and obligations of multiple parties, we have joint and solidary obligations. Here, you have to read Articles 1207 hanggang 1222. Let's discuss joint obligations first. According to Professor Balaning, a joint obligation is one in which each of the debtors is liable only for a proportionate part of the debt, or each creditor is entitled only to a proportionate part of the credit. In joint obligations, there are as many obligations as there as debtors multiplied by the number of creditors. There are three kinds of joint obligations. We have active joint, passive joint, and multiple joint. Active joint is where the obligation is joint on the creditor's side. Okay? Dito sa obligations na to, ang active party ay yung creditor, ang passive party ay ang debtor. Okay? So, for passive joint, where the obligation is joint on the debtor's side. For multiple joint naman, where there are multiple parties on each side of a joint obligation. So, pwedeng dalawa-tatlo ang creditor, dalawa-tatlo ang debtor. According to Professor Tolentino, the joint obligation has been variously termed as mancomunada or mancomunada, simple or pro rata. In a promissory note, the phrase, "we promise to pay," used by two or more signers, it now creates a pro rata liability and is a joint obligation. Okay? Again, in a promissory note, the phrase, "we promise to pay," signed by two persons or two people, two or more signers, now creating a pro rata liability or joint obligation. While "I promise to pay," followed by signatures of two or more persons, this is a solidary obligations, individually and collectively, individually and jointly. Yan ay solidary obligation. So, joint character is presumed when no stipulation as to liability of several debtors, presumption is joint, and each is liable only for his proportionate part of the obligation. So, as to several defendants, when solidarity has not been specified, The liability of the defendants is joint, and the court cannot amend it. What is the effect of joint liability? So the demand by one creditor upon one debtor produces the effects of default only with respect to the creditor who demanded and the debtor on whom the demand was made, but not with respect to others. So the interruption of prescription by the judicial demand of one creditor upon a debtor does not benefit the other creditors nor interrupt the prescription as to other debtors. On the same principle, a partial payment or acknowledgement made by one of several joint debtors does not stop the running of the statute of limitations as to the others. The vices of each obligation arising from the personal defect of a particular debtor or creditor does not affect the obligation or rights of the others. The insolvency of a debtor does not increase the liability of his co-debtors, nor does it authorize a creditor to demand anything from his co-creditors. In the joint divisible obligation, the defense of res judicata is not extended from one debtor to another, and this is according to Professor Manresa. We also need to read Article 1208. So, if from the law or the nature of or the wording of the obligations to which the preceding article refers, the contrary does not appear, the credit or debts shall be presumed to be divided into as many equal shares as there are creditors or debtors, the credits or debts being considered distinct from one another, subject to the rules of court governing the multiplicity of suits. So for this disjunctive obligation, it is not covered by the new civil code. There are two or more creditors. Here, there are two or more creditors and two or more debtors, but they are named disjunctively as debtors and creditors in the alternative. So the rules on solidary obligations here must apply, because if rules on alternative obligations will be applied, then the debtor will generally be given the choice to whom shall he give the payment. So example, A binds himself to pay 100 either to X or Y, or A or B will pay 100 to X. Ganon yung disjunctive obligation. So, let's go now to indivisible obligations. Article 1209. If the division is impossible, the right of the creditors may be prejudiced only by their collective acts, and the debt can be enforced only by proceeding against all the debtors if one of the latter should be insolvent. The other shall not be liable for his share. On the other hand, Article 1210, the indivisibility of an obligation does not necessarily give rise to solidarity, nor does solidarity or of itself imply indivisibility. Here, the obligation is joint even if the performance is indivisible. What do we mean by joint indivisible obligation? There are several debtors or creditors, but the prestation is indivisible. Again, there are several debtors or creditors, but the obligation or the prestation is indivisible. Example is delivery of a house or a determinate thing. Here, the fulfillment requires the concurrence of all debtors, although they are each for his part. And on the side of the creditors, collective action required for acts which may be prejudicial. So the consent is required and must still communicate choice after consensus. Let's go to Article 1224. Okay? A joint indivisible obligation gives rise to indemnity for damages from the time any one of the debtor does not comply with his undertaking. And the debtors who may have been ready to fulfill their promises shall not contribute to the indemnity beyond the corresponding portion of the price of the thing or of the value of the service in which the obligation consists. If there is plurality of creditors to only one debtor, as a general rule, the obligation can be performed by delivery of the object to all the creditors jointly. Delivery to only one creditor makes the debtor liable for damages to the other debtors for non-performance unless they have authorized this one creditor to collect in their behalf. If only one or some, not all creditors demand fulfillment, then the debtor may refuse to deliver and insist that all the creditors together receive the thing. If not, consignation to the court may be had. So in non-performance, the debtor is liable for damages. Here, with respect to damages, the prestation becomes divisible, and each creditor may recover proportionately. Question: is an obligation not to do divisible or not? The answer is no. Obligation not to do when there are several debtors is a joint indivisible obligation. Okay, let's now proceed to solidary obligations. So a solidary obligation is one in which the debtor is liable for the entire obligation, or each creditor is entitled to demand the whole obligation. If there is only one obligation, then it is a solidary obligation. There are three kinds of solidarity. Active solidarity, where there are several creditors with one debtor in a solidary obligation. Passive solidarity, where there is one creditor with several debtors solidarily bound. And mixed solidarity, when there are several creditors and several debtors in a solidary obligation. So, where there are no words used to indicate the character of a liability, the phrase, "I promise to pay," followed by the signatures of two or more persons, gives rise to an individual or solidary responsibility. The words individually and collectively also creates a solidary liability. So does an agreement to be individually liable or individually and jointly liable. Okay, let's focus now on active solidarity. Please read Article 1211 and 1207. Article 1211 states that solidarity may exist although the creditors and the debtors may not be bound in the same manner and by the same periods and conditions. Article 1207 states that the concurrence of two or more creditors or of two or more debtors in one and the same obligation does not imply that that each one of the former has a right to demand or that each one of the latter is bound to render entire compliance with the prestation. So there is solidary liability only when the obligation expressly so states or when the law or the nature of the obligation requires solidarity. So question: when is an obligation with several parties on either side joint or solidary? The presumption is that an obligation is joint because a joint obligation is less onerous than a solidary one. So there is solidary obligation in the following. Okay, number one, when the obligation expressly so states, so usually it is stipulated by the parties. Number two, when a will expressly makes charging or a condition in solidum. And number three, when the law requires, okay, in crimes, conspiracy, act of one is the act of one is the act of all. And in torts, joint tortfeasors. So the liability of joint tortfeasors, which include all persons who command, instigate, promote, encourage, advise, countenance, cooperate in, aid, or abet the commission of a tort, or who approve of it after it is done, if done for their benefit. That is according to Professor Tolentino. So also check the nature of the obligation. If it requires solidarity, that's under Article 19 to 22 of the new Civil Code. Okay, a moral wrong cannot be divided into parts; those must be solidary. And it is akin to quasi-delicts and quasi-contracts as discussed in Article 2183 and 2187. Also, if it is imposed by final judgment upon several defendants, okay, it must be expressed in the judgment or final order ng court and cannot be amended after finality. So these are the characteristics of active solidarity. Okay, the essence is mutual agency or mutual representation, which consists in the authority of each creditor to claim and enforce the rights of all with resulting obligation to pay each one what belongs to him. Okay, number one, since it is a reciprocal agency nga, the death of a solidary creditor does not transmit the solidarity to each of his heirs, but to all of them taken together. Okay, similar to Article 1005, when brothers and sisters of decedent inherit in their own right per capita, while nephews and nieces per stirpes by right of representation. Each creditor represents others in the act of requiring payment and in all other acts which tend to secure the credit or make it more advantageous. Okay, hence, if he receives only a partial payment, he must divide it among other creditors. He can interrupt the period of prescription or render the debtor in default for the benefit of all other creditors. So, a creditor once paid is shared equally. A credit once paid is shared equally among the creditors unless a different intention appears. The debtor may pay any of the creditors, but if any demand, judicial or extrajudicial is made, on him, he must pay only to the one demanding payment. That is from Article 1214. Okay, one creditor does not represent the others in such acts as novation and compensation and remission, even if the credit becomes more advantageous. In these cases, even if the debtor is released, the other creditors can still enforce their rights against the creditor who made the novation, compensation, or remission. And each creditor may renounce his right even against the will of the debtor, and the latter need not thereafter pay the obligation to the former. What are the characteristics of passive solidarity? Here naman, solidary yung debtors, okay? So, the essence is each debtor can be made to answer for the others, with the resulting right to the debtor-payer to recover from others their respective shares akin to mutual guarantee. And that is according to Professor Manresa. So, each debtor may be required to pay the entire obligation, but after payment, he can recover from the co-debtors their respective shares. And this is something similar to subrogation or subrogation. Okay? Interruption of prescription as to one debtor affects all the others, but the renunciation by one debtor of prescription already had does not prejudice the others, because the extinguishment of the obligation by prescription extinguishes also the mutual representation among the solidary debtors. The debtor who is required to pay may set up, by way of compensation, his own claim against the creditor. In this case, the effect is the same as that of payment. The total remission of the debt in favor of a debtor releases all the debtors, but when this remission affects only the share of one debtor, the other debtors are still liable for the balance of the obligation. All the debtors are liable for the loss of the thing due, even if such loss is caused by the fault of only one of them, or by fortuitous event after one of the debtors has incurred in delay. The interest due by reason of the delay of one of the debtors are borne by all of them. You have to note that an agreement to be individually liable or individually and jointly liable denotes a solidary obligation, not a joint obligation. Again, an agreement to be individually liable or individually and jointly liable denotes a solidary obligation, not a joint liability. Article 12.12. Each one of the solidary creditors may do whatever may be useful to the others, but not anything which may be prejudicial to the latter. Okay, acts beneficial. Each solidary debtor may interrupt prescription, constitute a debtor in default, and bring suit so that the obligation may produce interest. Acts prejudicial naman. Solidary creditor cannot do anything prejudicial to the others like remission, novation, compensation, merger, or confusion. But such provision in 1212 conflicts with 1215. According to Professor Tolentino, you have to harmonize Article 1212 and 1215 by such acts of extinguishment which is prejudicial to co-creditors would be valid so as to extinguish the claim versus the debtors, but not with respect to the rights of the co-creditors which subsists and may be enforced versus such creditor who performed the act alone. Article 1213. A solidary creditor cannot assign his rights without the consent of the others. Article 1214. The debtor may pay any one of the solidary creditors, but if any demand, judicial or extrajudicial, has been made by one of them, payment should be made to him. So, according to Professor Tolentino, mutual agency, which is the essence of active solidarity, implies mutual confidence. Thus, one creditor cannot assign or transfer his rights to another without the consent of the others. Bawal ipasa or i-assign, i-transfer ni creditor yung kanyang right sa iba without ng consent ng ibang creditors because ang kanilang foundation ay mutual agency, which is the essence of active solidarity and which implies mutual confidence. And this is the reason why the creditor cannot assign or transfer his rights without the consent of the other creditors. So what would be the effect of an unauthorized transfer pag transfer ni creditor yung rights niya without the consent of the other creditors? Here, there is no effect. No rights will be transferred. The assignee will not become a solidary creditor, and the co-creditors and debtors are not bound by such transfer. So it is as if walang transfer na naganap if the creditor would transfer his rights to another person without the consent of the other creditors. So the payment made by this assignee will not extinguish the obligation. A suit may be filed by him, may not interrupt the the period, except if the assignee is also one of the co-creditors. If the assignee is one of the creditors, because mutual confidence is incumbent. So, since co-creditor din yung assignee, then mai-interrupt yung period dito sa yung prescription. A suit filed by him may not interrupt prescription pag yung assignee is not a co-creditor. However, if a co-creditor has been assigned, if the co-creditor inassign or transfer yung right ng isang creditor because of mutual confidence and he is an incumbent co-creditor or creditor, yung prescription, may interrupt. As a general rule, a debtor may pay any of the solidary creditors. The exception is that if demand is made by one creditor upon the debtor, in which case the latter must pay the demanding creditor. Again, if demand is made by one creditor upon the debtor, in which case the latter must pay the demanding creditor only. How about judicial demand? Judicial demand. When such is made by one of solidary creditors, tacit mutual representation is deemed revoked. It is deemed revoked. Defendant debtor should pay to the plaintiff creditor to effect extinguishment, and payment to any one of other creditors who did not sue would be deemed payment to a third person. Of course, hindi naman siya yung demanding creditor. Bakit ka magbabayad sa iba, di ba? And the plaintiff creditor merely consolidates in himself the representation of all the others, but the essence of solidarity of creditors should not be nullified. How about extrajudicial demand? Same as the judicial demand. demand by several creditors separately, that the debtor should pay the one who notified him first. Kung sino yung naunang nag-notify sa kanya, dun siya magbayad. If they demand at the same time or collectively, the debtor may choose to whom to pay. Kung sabay-sabay silang nagdemand, okay, si debtor, pwede siyang mamili kung kanino siya doon magbabayad. These are the other instances. Debtor upon whom demand was made pays to a creditor other than the one who made the demand in violation of Article 1214. This is considered payment to a third person kasi nagbayad siya doon sa creditor na hindi nagde-demand. Doon ka magbayad sa creditor na nagde-demand. Okay? Debtor upon whom demand was made pays to the creditor other than the one who made the demand in violation of Article 1214. Sabi ni Article 1214, paragraph 2, the debtor can still be made to pay the debt. The only concession given to the debtor is that he is allowed to deduct the share of the receiving creditor from the total amount due even if he paid the entire amount due to that creditor. Okay, creditor A makes demand on debtor Y. Does it mean that he cannot pay the share pertaining to creditor B? The answer is, according to the commentators, he can, but this is dangerous because there may already be an agreement on the part of the creditors, okay? Question again, there are three creditors, A, B, and C. And there are three debtors, X, Y, and Z. A makes a demand on Y. Tapos, si X pays B. What is the answer? The answer is, this is not covered by Article 1214. Nanggugulo lang, okay? Let's proceed now to novation, compensation, confusion, or remission of the debt made by any of the solidary creditors or with any of the solidary debtors, and it shall extinguish the obligation without prejudice to the provisions of Article 1219. Itong novation, compensation, confusion, or remission of the debt, nasa Article 1215 ito. So you have to read Article 1215. The creditor who may have executed any of these acts, as well as he who collects the debt, shall be liable to the others for share in the obligation corresponding to them. Okay. 1219, Article 1219, the remission made by the creditor of the share which affects one of the solidary debtors does not release the latter from his responsibility towards the co-debtors in case the debt has been totally paid by any of them before the remission was made. Article 1915. If two or more persons have appointed an agent for a common transaction or undertaking, they shall be solidarily liable to the agent for all the consequences of the agency. Okay. So let's go now here. In a joint obligation with V, W, X, Y, and Z as debtors and A and B as creditors in the amount of 900,000 pesos, how much can A validly demand from V? The correct answer is 90,000 pesos. How did we come up with 90,000 pesos? Okay. Pursuant to Article 1208, there are a total of 10 obligations, 5 debtors and 2 creditors. So you have to multiply 5 times 2 in order for you to get 10, which is the number of obligations in this question. Then 900,000 pesos, which is the total amount of obligation divided by the number of the obligation, and the quotient is 90,000 pesos. So this is the only amount which A can validly demand from V. Next question. Okay. How much can V recover from W if he paid the amount that A can compel him to pay? The correct answer is none because V only paid his own share in the debt. Last question. How much should A give to B if V paid him the amount that he can compel V to pay? The correct answer is none. A only collected his share in the credit. Remember that this is a joint obligation. Next. In a solidary obligation naman, with V, W, X, Y, and Z as debtors and A and B as creditors in the amount of 900,000 pesos, how much can A validly demand from X? The correct answer is 900,000 pesos. Why? So how did we come up with 900,000 pesos? In a solidary obligation, any one of the debtors may be compelled to pay for the whole amount of the debt. So how much can X recover from W if he paid the amount that A can compel him to pay? The correct answer is 180,000 pesos. Okay? So unless there is a stipulation, debtors in a solidary obligation share equally in paying the entire obligation. Last, how much should A give to B if X paid him the amount that he can compel X to pay? The correct answer is 450,000 pesos. Unless there is a stipulation, creditors in a solidary obligation share equally in the credit. Okay.